Hi, I'm Vermont Secretary of State Sarah Copeland Hansis.
And I'm Deputy Secretary of State Lauren Hibbert.
And I'm Jenny Prosser, the Secretary of State's General Counsel and Director of Municipal Assistance.
Transparency is an essential element of an open, democratic government. In Vermont, our open meeting law ensures that meetings of governmental bodies remain accessible to the public. This accessibility creates a foundation for trust and participation, which in turn makes government more effective. The law declares that all meetings of governmental public bodies must be open to the public at all times, with rare exceptions. The open meeting law empowers members of the public to play an effective role as an active participant in government and as a check on it. In 2024, the Vermont legislature updated the open meeting law with Act 133 to recognize that hybrid and remote access to public meetings can strengthen civic engagement and support transparent, efficient government decision-making. In this video, we'll cover the basics of what you need to know about Vermont's open meeting law, including those recent changes. As we dive into the details, please keep in mind that other laws also govern your public meetings, like public accommodations laws and other anti-discrimination protections, as well as any requirements pertaining to your specific type of public body or your municipality's own governance charter. And remember, we at the Secretary of State's office provide education, not legal advice. You can rely on the Secretary of State to share what we know about the law, to highlight any changes or gray areas, and to point you to reliable resources for additional help. If you need legal advice about how to proceed in a specific scenario, we recommend consulting with your town council or a private attorney. When in doubt, focus on the intent of the law, to provide for transparency and accountability in government by requiring public bodies to come to consensus in decision-making before the public and with participation that's accessible to all. That's the spirit behind all the details.
So what exactly is the open meeting law? In order to make for transparent and accessible public meetings, the Vermont legislature put some key rules in place. You can read these rules for yourself by starting to take a look at Title I in the Green Books at your town clerk's office or the Vermont statutes on the Vermont legislature's website. Broadly speaking, the law requires public bodies to do their work before the public. Wait, what is a public body? A public body means any state or municipal board, council, or commission, including all committees and subcommittees of these bodies. You are going to hear the term public bodies a lot here. It is just the most succinct term that covers all the different kinds of boards, councils, commissions, and other groups to whom the open meeting law applies. Public bodies include state and regional boards, councils, and commissions. At the local level, it includes select boards, school boards, planning commissions, development review boards, boards of civil authority and abatement, boards of auditors and of listers, municipal public library boards of trustees, cemetery and recreation commissions, and various other governmental groups referenced in state statute or by municipal charter. Public bodies also includes any committee or subcommittee that is created or empowered by a public body to do the body's work, no matter the size or membership. The open meeting law has four main facets. First, public bodies must provide advance public notice of their meetings, including the agenda. 2, public bodies must discuss all business and take all action in open meeting, unless an exception exists in the statute. 3, members of the public must be able to attend and participate in meetings, whether the meeting is conducted in person, remotely via electronic means, or in a hybrid fashion. And public bodies must keep a publicly available record of their meetings. All public bodies must take meeting minutes and make these minutes available to the public within 5 calendar days after the meeting. We'll talk about the new rules for electronically recorded public meetings later on. That said, the open meeting law does not apply to individual officials in their work, nor does it generally apply to nonprofit corporations or other private boards unless otherwise specified in their governance documents or as a condition of a grant or contract.
Now that we know all public bodies must follow the open meeting law's requirements for public notice, public decision-making, public participation, and minutes, when do these requirements kick in exactly? And how do public bodies comply? The open meeting law's requirements are triggered anytime a public body holds a meeting. A meeting occurs anytime a quorum of the body's members gathers to discuss business or to take action. A quorum is usually the majority of the entire body's membership, and this law outside the open meeting law requires otherwise. To calculate the majority, start by counting seats, not heads. Even if seats aren't filled, they count towards quorum. For example, a 15-member board, even if several seats are vacant, would need 8 members present to make a quorum. Business means the body's governmental functions, including any matters over which it has supervision, control, jurisdiction, or advisory power. Note that meetings can occur regardless of the member's physical location. We'll talk more about virtual meetings later. If a majority of members find themselves together at a social function, they must take care not to discuss the body's business. The open meeting law can also be triggered by a discussion of business involving a quorum that occurs asynchronously or over time, such as a string of emails or social media posts. So then, do all gatherings of a quorum count as meetings? No. Not every interaction of a public body's members is considered a meeting for the open meeting law's purposes. We'll give you 3 common examples of gatherings that are not subject to the open meeting law. Communications made to schedule a meeting, organize an agenda, or distribute materials to discuss at a future meeting are not considered a meeting under the law, provided that no other business of the public body is discussed or conducted. These communications are, however, subject to Vermont's Public Records Act, and so any record of them must be made available to the public upon request for inspection and copying, unless an explicit exemption in statute applies. Occasions when a quorum of a public body attends social gatherings, conventions, training programs, press conferences, media events, or otherwise gathers are also not considered meetings under the open meeting law, provided that the public body does not discuss specific business that, at the time of the exchange, the participating members expect to be taken up as business of the body at a future time. And a gathering of a quorum of a public body at a duly warned meeting of another different public body is not a meeting, provided that the attending public body does not take action on its business. There are assorted other carve-outs from the definition of meeting that might apply to the work of certain boards at certain times. For example, site inspections for tax assessments or abatements, routine day-to-day administrative matters that do not require action by the public body if no money is appropriated, spent, or encumbered, and bilateral collective bargaining negotiations between a school board negotiating committee and a labor union. In sum, a public body must comply with the open meeting law when a quorum gathers to discuss business or take action, unless an explicit exception from the definition of meeting applies. Next, let's talk about meeting requirements. First up, notice.
For the purposes of advanced public notice under the open meeting law, there are 3 types of meetings: regular, special, and emergency. A regular meeting is just that, the ones you have scheduled to occur weekly, bi-weekly, monthly, usually via a publicly available resolution that states the time and place. A special meeting is also pretty self-explanatory. These are meetings that are held outside of the regular schedule. But what makes a meeting an emergency meeting? These are held in the event of a true emergency, only when necessary to respond to an unforeseen occurrence or a condition requiring immediate attention. How does a body provide notice of a meeting, and what about meeting agendas? For regular meetings, you don't have to give additional notice before each meeting as long as the schedule has already been clearly designated. You do need to post that agenda online 48 hours before the meeting on a website that the public body maintains or designates. Municipal public bodies must post the agenda for regular meetings in or near the municipal office and at least 2 other designated public places in the municipality at least 48 hours prior. For special meetings, the time frame for posting notice and agendas is 24 hours. The public body must also give notice of the meeting's time, place, and purpose to a newspaper or radio station serving the area, as well as to any person who is requested in writing to be notified of special meetings, and to each member of the public body, unless a member has waived notice. For emergency meetings, the law only requires some notice as soon as possible. Here, focus on the open meeting law's underlying purpose, transparency and accountability. If you can manage 24 hours notice, then we recommend conducting a special meeting rather than an emergency one.
What should be on the agenda? Well, start with the date, time, and location of the meeting. You should also include each specific topic that will be discussed and, to the extent possible, potential actions the body may take. If you anticipate an executive session, more about these later, it can be helpful to note this as well. Additional requirements may come into play when conducting meetings that involve electronic participation. What about minutes? Public bodies must take written minutes of all meetings. Minutes are the permanent record of the formal actions of the public body and play an important role in recording the history of the public body's business. The open meeting law requires that minutes give a true indication of the business of the meeting, covering all topics that arise. At minimum, minutes must include the names of all members of the public body who are present at the meeting, the names of all other active participants, all motions, proposals, and resolutions made and their dispositions, and the results of all votes, with a record of individual votes if roll call is taken. Minutes are public records and must be made available for public inspection and copying after 5 calendar days from the date of the meeting. If a public body maintains or designates a website, minutes must also be posted to that website no later than 5 calendar days after the meeting. Except for draft minutes replaced with updated minutes, posted minutes must not be removed from the website sooner than 1 year from the date of the meeting for which they were taken. We've covered advance public notice and minutes, which are fairly straightforward. Now, we'll address the open part of open meetings.
Generally speaking, public bodies must conduct all discussions and make all decisions in a duly warned, open meeting before the public. It's worth noting, though, that this doesn't necessarily require all members of the public body to be in the same room. Even before the COVID-19 pandemic and resulting updates to the law that we'll discuss in a bit, the open meeting law allowed remote participation for members of a public body. Specifically, the open meeting law permits 1 or more members of a public body to attend public meetings electronically from a remote location under certain parameters. Each member who attends remotely must self-identify at the start of the meeting and must be able to hear and be heard throughout the meeting. Any vote that's not unanimous must be taken by roll call. And if a quorum or more is attending electronically without being physically present, then generally the agenda must designate a physical location that will be staffed and available to the public to attend and participate in the meeting. We'll get into some exceptions when we cover the 2024 amendments to the open meeting law later in this presentation.
So can a public body ever meet privately? Yes, in 2 specific situations. The open meeting law recognizes that private discussions among a quorum of a public body may be advisable. Those two scenarios are deliberative sessions and executive sessions. A deliberative session occurs only when a public body holds a quasi-judicial proceeding, acting like a court by adjudicating the legal rights of parties, taking evidence, examining witnesses, and producing an appealable written decision. Quasi-judicial hearings conducted by public bodies are meetings open to the public. Still, the public body may discuss and weigh evidence received during the hearing in a private deliberation, much like a jury does. Once a written decision is drafted, it need not be adopted in open meeting if it is to be issued as a public record. For contrast, an executive session is a closed portion of a public meeting that can only be used to discuss specific topics that the Vermont legislature has deemed appropriate for private discussion. There are 15 specific topics named in the open meeting law. To enter an executive session, a motion must be made in open session that indicates the reason for doing so, preferably naming the specific provision of the open meeting law that gives the authority to go into executive session. For a municipal body, the motion must get a majority vote of those present to pass. For a state body, a 2/3 affirmative vote is required. Once in executive session, discussion must be limited to permissible topics, and no formal action may be taken, except for actions related to securing a real estate purchase. This differs from a deliberative session, in which decisions may be made so long as a written decision is issued that is a public record. Any formal action in an executive session must be taken by motion and voted after the public has re-entered open session. Misuse of executive sessions goes against the purpose of open meeting. Public bodies should close their meetings rarely, and then only for legitimate purposes. Some bodies choose to go beyond the requirements of open meeting law and do everything in public, except for when acting in a quasi-judicial capacity, where constitutional due process may require private deliberations. The risks involved in letting everyone know of a public body's business are not small. Nevertheless, there is generally no penalty for extra openness, and there is a high return on the investment if the public understands that you have nothing to hide.
The open meeting law isn't just about acting in front of the public, it's also about acting with the public. Now we'll talk about public participation. What rights do members of the public have under the open meeting law? The public has the right to obtain meeting agendas in advance, to be notified directly of upcoming special meetings, and to view or copy meeting minutes. Agendas for regular or special meetings must be made available to any person before a meeting upon request. In addition, anyone can request in writing that a public body notify them of special meetings of the body. The request applies to the calendar year in which it was made, except that requests made in December also apply to the following calendar year. Meeting minutes, either in draft or final form, must be made available for inspection and copying no more than 5 calendar days from the date of any meeting. Members of the public have the right to attend public meetings. Meetings of public bodies are also subject to the public accommodations requirements detailed in Vermont's anti-discrimination statutes. When a public body decides to meet in private in executive session, members of the public have the right to know its reason for doing so. It is best practice for a body to call a motion with a clearly identified reason for the executive session. Members of the public also have the right to participate in public meetings. Specifically, public bodies must give members of the public a reasonable opportunity to express their opinions on matters being considered by the body at an open meeting, except for quasi-judicial hearings because of due process considerations. Many boards allow public comment at the start of the meeting, while others place it as the final agenda item. Some boards allow public comment whenever anyone present has something to add to the discussion. We believe it is a best practice to allow the public to comment on each item as the board proceeds through the agenda. The public comment period, however, is not a free-for-all. The board chair may establish reasonable rules to maintain order, and reasonable limitations on the amount of time for each speaker are not unusual or improper.
So, public bodies must conduct their meetings in public, provide advance notice, minutes, and opportunities for members of the public to participate. What happens if a public body violates the open meeting law? Well, there can be criminal penalties, misdemeanors, and fines for knowing and intentional violation of the open meeting law. These penalties can accrue to members of the public body who violate the law, any person who violates the law on behalf of a public body member, or any person who participates in someone's wrongful exclusion from a meeting. More commonly, though, enforcement occurs when a member of the public or the Vermont Attorney General files a suit in court asking the court to make a call about whether a violation occurred and the appropriate remedy. That might be a declaratory judgment, which is a binding determination of the party's rights, or injunctive relief, requiring the public body to do something or to stop doing something. Under some circumstances, the court may also hold a public body responsible for the other party's attorney's fees and litigation costs. So how does citizen enforcement of the open meeting law work? If a member of the public believes that an open meeting law violation has occurred, their first step is to submit written notice to the public body, alleging a specific violation and requesting a specific cure. Upon receipt of this written notice, the public body must respond publicly within 10 calendar days, either by acknowledging the violation and stating its intent to cure it, or by stating its determination that no violation occurred, so no cure is necessary. Failure to publicly respond is treated as a denial of the violation. If the public body acknowledges a violation, it must cure the violation within 14 calendar days. First, the public body must publicly either ratify or declare as void any action that was taken at or resulted from a meeting that was improperly noticed, a meeting that a person or the public was wrongfully excluded from, or an executive session or a part of an executive session that was not authorized. Second, the public body must adopt specific measures that actually prevent future violations. If the public body denies the violation or fails to cure an acknowledged violation in a timely manner, the aggrieved individual can file suit against the public body in the Civil Division of the Superior Court in the county where the alleged violation took place. The suit must be brought within 1 year after the meeting where the violation occurred or to which the violation relates. The court will then decide whether a violation occurred and whether a declaratory judgment or injunctive relief is appropriate, and whether circumstances require the public body to pay attorney's fees and litigation costs. Of course, it generally does not need to come to this. As we mentioned earlier, the spirit of the law is about how transparency yields trust. There are guardrails to prevent willful disregard for open meeting law, but the whole point here is that by removing barriers between you and the public, you're creating the conditions to be proactive rather than reactive.
That is an overview of the longstanding open meeting law. Now we'd like to share a summary of recent updates to the law. In response to lessons learned during the COVID-19 pandemic, the Vermont legislature enacted Act 133 of 2024 to address hybrid and remote meetings and meeting accessibility. Act 133 made some changes and additions to open meeting law, primarily to do with the format in which a meeting can be held, depending on the different types of public bodies and their scope. For the last part of this video, we're going to break down these updates. At the threshold, the new amendments require each public body to determine whether it is advisory or non-advisory by considering its decision-making power. Advisory public bodies are just that, bodies that only advise. Advisory public bodies do not have final decision-making authority. They instead provide advice to those who do make final decisions. By contrast, and despite the negative in the term, non-advisory public bodies have more responsibility. Non-advisory bodies have final say over key decisions. Specifically, non-advisory bodies have final decision-making authority over at least one of the following: legislative, tax, budgetary, or quasi-judicial matters. This is why non-advisory bodies must now meet more stringent standards for accessibility and accountability. For clarity's sake, we'll refer to non-advisory bodies as decision-making bodies for the rest of this presentation, but now you know the language of the law. Wondering how to classify your public body? Think about the types of decisions your body makes. If you have power to make final legislative, tax, budgetary, or quasi-judicial decisions, you are decision-making and non-advisory. Still unsure? This is a good time to consult your body's own legal counsel, or alternatively, your body can default to the requirements for decision-making bodies, since these are the stricter of the two.
Okay, so you're a public body that does not have any final decision-making authority over legislative, tax, budgetary, or quasi-judicial matters. You're an advisory public body. What does Act 133 say about your meetings? Any advisory body meeting, whether state or local, may now be remote only. You don't have to provide a physical meeting location at all. Of course, you can if you want to. Well-run hybrid meetings are generally the gold standard for accessibility, so that's always welcomed. You do have to make sure that any remote-only meetings you hold are accessible to the public by using an electronic platform that allows for direct access and participation, by offering a telephone option, and by including info that allows for direct access by the public in the published agenda or notice for the meeting. Advisory bodies are not required to electronically record their meetings, but again, you certainly may if you think that recording and posting will help maximize access to your meetings.
All right, so you're a decision-making public body. You are non-advisory. What does Act 133 mean for you? Two more distinctions here. Do you have statewide authority or local authority? State decision-making public bodies have two new duties when conducting meetings. First, regular and special meetings of state decision-making bodies must be hybrid. This means that the body must designate a physical location where the public can attend and participate, as well as an electronic platform for folks to directly access and participate in the meeting remotely, including telephone access. Each meeting's agendas or notices must include information about how the public may directly access the meeting, even remotely. Second, state decision-making bodies must video record their meetings and post these recordings in a designated electronic location. The recordings must remain posted online and must otherwise be retained by the public body for at least 30 days following the approval and posting of the minutes for that meeting. Counting here might be a bit tricky. Of course, we recommend posting your meeting recording as soon as possible after the meeting, and your minutes must be posted in at least draft form within 5 calendar days. But you typically would not start counting the 30 days for removing your electronic recording until after your body's next scheduled meeting, when your body approves the minutes for the meeting to which the recording relates. If you're a local decision-making body, it is the body's choice whether to conduct meetings in a hybrid manner. That means offering an online live platform. Regardless of that decision, each local decision-making body must provide a designated, staffed, physical location for each regular and special meeting where the public may attend and participate. This is not a change to the long-standing law and is essentially the same requirement that existed prior to the COVID era. Like state decision-making bodies, local decision-making bodies must record their meetings and post those recordings in a designated electronic location for at least 30 days after the minutes for that meeting have been approved or posted. For local decision-making bodies, however, recordings may be audio only, and the recording requirement may be waived altogether by a municipality that demonstrates undue hardship. We'll talk more about what undue hardship entails soon. There are exceptions here for emergencies and more localized incidents. We'll discuss these types of situations in more detail in a moment. For now, just note that when an emergency meeting is called, as the open meeting law allows, it may be conducted as remote only, without a designated staffed physical location. This is true for both state and local decision-making bodies. And when the governor declares a state of emergency, or when a local incident impedes a public body's ability to hold a meeting in its usual fashion, any affected public body may conduct meetings as either remote only or in-person only, as makes sense according to the conditions. Those are the main aspects of Act 133 that changed. Now let's take a look at some of the details.
We mentioned that local decision-making bodies must electronically record their meetings with either audio or video, unless they can prove that this would cause undue hardship. What's that mean? First, this only applies to municipal bodies. If the municipality can prove that recording their meetings and posting that recording would require significant difficulty or expense in terms of their size, personnel and staffing, budget and cost, then they don't have to electronically record their meetings. The burden of proving undue hardship is on the municipality. We recommend that any municipality claiming this exemption have its legislative body document its finding after hearing relevant supporting evidence during an open public meeting and record its finding in the minutes. The idea here is to recognize that for some very small towns in Vermont, meeting accessibility is still important, but technological or staffing challenges might make it difficult to always record the meetings.
Let's talk about meeting accessibility a little more. When we say accessibility, we mean removing barriers that people might face in accessing or taking part in a meeting. This can look like a variety of things, from a meeting time that's during work hours, to a building not having a good entrance for wheelchair users, to a room with poor acoustics or bad lighting. Part of open meeting law is about having rules in place that create good conditions for accessibility, but in some instances, there still might be barriers remaining for folks. This is where requests for access come in. This is a new option under open meeting law that allows any resident of the public body's jurisdiction, a member of the public body itself, or a member of the press to request additional access to a regular meeting. A request for access must be submitted in writing to the public body at least 2 business days before the meeting and specify what type of access is being sought. It is important to include contact information. And importantly, people do not need to provide any basis for their request. If your public body receives a request for access to a regular meeting, you must generally honor it. Again, there are some exceptions. Requests for access are limited to the next regular meeting, not a series of meetings, or a special meeting, or an emergency meeting. And a public body does not need to grant a request for access during an all hazards event, a declared state of emergency, or a local incident. Or in the case of a municipal public body, where the public body can show that compliance would impose undue hardship. Undue hardship here has the same meaning as we were discussing in the context of recordings for municipal meetings, where compliance would require significant difficulty or expense, looking at the factors such as entity size, personnel and staffing, budget, and cost.
Sometimes things get in the way of holding ideal open meetings. If the governor declares a state of emergency, any affected public body may hold remote-only meetings during that time. Notice to the public of any alteration in the meeting location due to state of emergency must be provided in the same way you would warn a special meeting. Now, the open meeting law similarly allows a public body affected by a local incident to meet remote only or to meet exclusively at a physical location if the body's ability to provide electronic access is impeded. Local incidents are situations where the normal way a public body would meet is obstructed to the point that it wouldn't be feasible. This could look like a serious weather event, loss of power or telecom, a public health or safety emergency, or a received threat to a member of the public. The key here is that the problem directly impedes the ability of the public body to meet in its usual way. To change how an affected public body meets during a local incident, the highest ranking officer of the public body must make a formal written finding and announcement of the local incident, including a basis for the finding. As with meetings held during a declared state of emergency, the public body should also publicly announce and post info about the meeting changes due to a local incident like it would in giving notice for a special meeting. Although in this situation, an affected municipal public body is permitted to replace up to 2 of its physical postings with postings in publicly accessible designated electronic locations, provided that the agenda or notice is physically posted in or near the municipal clerk's office.
Thanks for taking the time to view this training video, and thank you for your service as you work to support the vibrancy and health of Vermont's civic life. Serving on a public body is a considerable commitment. The decisions that public bodies make impact Vermonters' lives every day. Decisions on how city and town funds are spent, how a road is managed, what the bus schedule is for a school, how land is zoned, how a profession is regulated, or how a town library is accessed and managed matter to Vermonters.
Ultimately, if members of the public understand those decisions, even if they don't agree with them, the community will embrace the decisions that have been made. Open meetings and transparent government help build trust in government and the democratic process. The Secretary of State's office commends the legislature for making modifications to open meeting law that reflect the lessons learned during COVID. And ultimately, we believe these changes make serving on a public body and public participation easier and more convenient.
If you have questions for us about the open meeting law, you can contact us. Reach out to us at 802-828-2363 or visit our website. And for records-related questions, our State Archives specialists are also ready to help.